is no power of attorney, there is no trust, maybe this came on suddenly, or that those steps were never taken, what do you do?
Well, if they don't have capacity to sign, then they really can't transfer their house.
Hi, I'm Karen Totino with Downsize Saratoga and Monticello Real Estate, and I'm here with Debra Verni, who's an estate attorney with Rollins, LeBrew, and Griesmer. And we are going to tackle the dilemma or question of what to do when your parent has dementia and you need to sell their home. You have a parent that is, and it doesn't have to be necessarily dementia, it could be a stroke or just something that impairs their cognitive functioning, that they need more care and they can't stay in their home any longer. What does that child do for their parent, and how do they sell their home?
In the perfect world, they would have transferred their house to a trust so that the trustee would be able to sell the house and find suitable housing. Another perfect world, they would have a power of attorney. But what you have to understand with the power of attorney is the person is supposed to act in their best interest or at their direction. So is it in their best interest, right, to sell the house? Or if they have dementia, a lot of times they can't give direction, or they give muddled directions. This is what I want, this is what I don't want, and then the next day it could be something completely different.
Right.
But you have to be really careful, because if it is someone that has dementia, then they don't do well with change. So you need to make sure that the person is ready to move and that you have everything in order to be able to do it, because if you don't, then it's going to be very difficult on them.
Right.
But if you have a power of attorney, the power of attorney, again, if it's in their best interest or at their direction, they could sign the paperwork to sell the house, and they could sell the house. If it was in a trust, then the trustee would be able to do that.
That is the best case scenario, but probably the worst case scenario is there is no power of attorney, there is no trust. Maybe this came on suddenly, or that those steps were never taken. What do you do?
Well, if they don't have capacity to sign, then they really can't transfer their house. A lot of times when we have cases where there's a single parent and they can't sell the house, then unfortunately we would have to bring a guardianship proceeding. The only way to get power over that person to be able to make a transfer would be to get a guardianship proceeding, which is very, very invasive, very, very expensive. Not something you want to do unless you absolutely have to. So again, best bet is to pre-plan and get a power of attorney.
That's the moral of this story.
That's right. The moral pre-plan would be to get a power of attorney in place and or a trust, or both. Whenever we meet with clients, we really try to get them, if nothing else, to do a power of attorney, because that's the most important document that you can have. Right.
Maybe that parent made a close family friend a power of attorney, and then if you're the child, then you have to kind of work through their friend, right, and come to a consensus, right, on how to move forward.
That's what's difficult. A lot of people do the powers of attorney when the kids are small, right? So they're not going to name their kids, and then they never look at their documents again, right? They do the docs, they throw them in a drawer, and then 20 years later, their sister who's deceased or their best friend is their power of attorney, and now there's no one that can act. So we generally tell people they should look at their documents every 5 years, just to make sure that that person is someone that they want. And unfortunately, all of us are aging in place right now, whether we like it or not. So a lot of my clients that did their documents 20 years ago and named each other, right? And now they're both about the same age. I tell them that maybe, you can still be power of attorney for each other, but why don't you add one of the kids as an or, right? So that
you can have kind of a chain of command here.
Your chain of command. You can have or. So powers of attorney can be this person and this person, where they both have to act. This person or this person. So either or could act. Or you can put in like a pecking order, this person, then this person, then this person. So I always like to have a deep bench as far as powers of attorney go. But a lot of people will do and, so that they have checks and balances.
And that can maybe give them more peace of mind and more comfort,
Yeah, because it's a very powerful document.
It is.
So you need to make sure that the person that you appoint is someone that you trust.
And I'm just thinking, when there's a lot of children and you need one child, you know, I imagine there's a lot of times when there's differing opinions, you know, no, well, let's keep mom or dad at home. But essentially, it's the person with the power of attorney that decides, right? Okay.
Again, that's the rules. I mean,
Right.
the only thing that ties their hands is it in their best interest, or is it their direction to do it? And that's really the only reason you can use the power of attorney. But like you said, what if I say it's the best interest for mom to stay home and get caregivers, and you say it's in her best interest for her to go into assisted living? So, right, which one of us is looking out for her best interest? So
yeah, it's just a matter of opinion.
it's a matter of opinion, yes.
Yeah.
So a lot of times, you know, you can ask the medical profession, you know, do you think it'd be better to keep her in her home with care or move her into assisted living? Sometimes if someone's bad enough, they really do need to go to memory care. And if you're at that level, then it is better for them to be in maybe memory care, so that someone can be with them and take care of them, especially if all the kids are working and there's no one to take care of them.
Is some of this spelled out in a living will, like where you kind of go deeper into, like, if this is the situation, this is how I want to be cared for, if that's that situation, is that?
A living will is more of an end of life thing.
Okay.
It says, if the doctor comes out and says, I'm not coming back, give me good drugs and let me go. There are some living wills that are specific for people with Alzheimer's dementia. I actually had a woman that gave me all the language, and that's how she wanted hers, and it was very interesting. We drafted it, and that's how she wanted things to go. She wanted to be able to, if she suffered from dementia, if she had this, if she had that, it was very specific as to how she wanted to be treated and what she wanted done. And I really haven't done one since then, because no one's asked for that specific language, but we do have it.
Okay, so it is possible. Well, this was all very, I think, helpful, and I think the really take-home point is to be prepared and to have those difficult conversations with your family and decide who you want to be your power of attorney, and make sure you have a power of attorney.
Yes, definitely have a power of attorney. Best bet, have a trust.
Yes, yes. Okay. So if you have any questions for Deborah, please, you can always reach out to either one of us. We'll have our contact information. And if you have kind of a broad question, feel free to leave them in the comments. So